All right. Hello, everyone. It's really great to be here in Atlanta and to meet so many people who are determined and so perceptive about the issue of general autonomy all in the same place. So today I'd like to share with you a broad overview of some of the formal methods of redress that I'm exploring. So what will I share? I will talk about the types of different proceedings, the different theory behind causes of action, some of the past cases, a word about my own legal case as a plaintiff in Canada, where I was born, where I aim to raise the issue and challenge it legally, and also some of the obstacles that plaintiffs face when they try to seek a formal method of redress. So I'd first like to start out with a disclaimer. I'm not a lawyer. I'm, as a science student, someone who's not legally trained, but I would like to share some information that is important to be aware of and can help in the approach to these types of strategies in combating the general autonomy issue. Also, laws vary a lot between different areas. They vary so much between states, let alone between Canada and the States. So I will be quite broad, but there are a lot of things that are in common with the different rules and in proceedings between the different areas. So I want to start out by distinguishing what are the state medical boards versus a civil lawsuit. So every state has a CARE Act that delegates the different legal aspects of the medical profession to different boards. These can be called medical commissions, they can be called medical registration boards, and in Canada we have these colleges of physicians. So the complaints in these entities are not lawsuits, but they do deal with the regulatory side of things and the standard of care. There is quite a large variation in what different boards will disclose and how open they are to the topic. I find that the one in British Columbia is the most forward-thinking, albeit there is a lot of room to improve in what information that they share. So what do these boards do? They take care of medical licensing. They arrange disciplinary infraction proceedings, and also they can refer matters to different committees within these entities. But what they can't do is they cannot award any damages, and oftentimes they can't really decide on legal issues. So a lot of it really is about the standard of care and how this interacts with what doctors are trained to do and what they're trained to say, and perhaps trained to not say oftentimes. So I'd like to give a subjective overview of what I've experienced when approaching these bodies and what I've seen. So I've seen that they really try to steer away from the issue, and they're quite aversive. It does seem that when they are approached with complaints, they tend to do a kabuki theater, where they go through these motions of pretending to do all of the steps and to be listening, when they're really just looking for people to leave them alone about this. But I think it's important that we let them hear it, because it takes time. I won't be the first person to make a complaint to them, and I certainly won't be the last. I also find that these bodies, they won't try so hard to defend the practice up front, but they'll give these wishy-washy reasons and technicalities for why it's permitted or why their doctors didn't act unethically. So it's been said that these entities act a lot like trade organizations, which have an interest in protecting their members, the doctors, right? I will find that they also put a great deal of effort into congratulating themselves about how forward-thinking they are, about how committed they are to change, and how much they care about evidence-based medicine, when that really is only the case when it's convenient, it seems. So I'd like to make them walk the walk. So it's important to point out that these complaints are not lawsuits. These bodies have less jurisdiction, and they are not allowed to decide questions of law in some ways, which is kind of counterintuitive, because isn't what they're doing upholding the standard of care, and aren't they the interface between the medical profession and what they are legally obliged to do and not do? So I find that these proceedings have some advantages for people who are looking to make their story known and to make a difference. It's less risky than a civil proceeding, and it's much less costly, but also, since you're approaching the very institutions and entities that are perpetuators of the issue, they are in a way less likely to really consider what you have to say and really want you to leave them alone. So there's a lot of this, well, if we just don't look, maybe they'll go away kind of attitude that goes on. So I complained to the College of Physicians and Surgeons of Ontario, where my personal case happened, and my complaint listed 5 main points: unnecessary physical and psychological damage, the breach of rights that were guaranteed to me by the Charter of Rights and Freedoms, which is our Canadian version of a newer document that came in the 80s that outlines all of the rights that we are guaranteed that are inalienable rights, and also a lot of detail about the problems with the consent that was secured and continues to be secured from parents. So I was very transparent in my complaint. I said that there's a wider issue, and I said that I think as the College of Physicians and Surgeons of Ontario, who are obligated to commit to quality care and uphold the standard of care, should do something about this. The response was pretty boilerplate and flat. They essentially ignored all the main points. I went through a great effort to explain why surrogate consent has a limited scope. Parents can't simply consent to anything for their children. There needs to be a demonstrated medical need. And why the child's needs supersede what the parent wants, especially when we're going to propose an invasive intervention, an irreversible one. Well, the response to these issues with surrogate consent was, surrogate consent exists. It seems that the response is just repeating to me what I already know, but not addressing the actual issue at hand. Another thing that I found very interesting was that they seemed to be satisfied with something that they admitted they didn't have enough information about with this consent process, which was a bit contradictory. So I appealed this with the Health Professions Appeal and Review Board, which is the next step. And their only jurisdiction is determining whether the committee's decision was reasonable, which gives them a lot of leeway, a lot of room to hide, it seems. And so they essentially were just replying with, well, the parent signed the form, therefore it must be okay, even though I had already explained that my parents could have signed the form 1,000,000 times, but it still wouldn't be right. No matter how many signatures there are, it doesn't make them magically informed, right? So it did feel like you're talking to one of those pull string toys, which will say the exact same thing no matter what. So with civil cases, I want to give an overview of some of the different main ideas for different claims that exist. And keep in mind, these are different between areas, and some cases can be stronger depending on which areas they are in, just based off of the laws there. So a lot of them are based off of the same core points: the unnecessary nature of the surgery and the fact that there's no legally operative consent. What do I mean by that? There are problems with this consent or lack of consent that is passed off as appropriate. So surrogate consent, limited in scope. Parents cannot decide to force upon their children unnecessary medical interventions that do not have medical justification. The parents are almost all the time uninformed, and you can't make a contract involving an illegal action, which is inflicting physical harm upon a child for no justifiable reason. So with assault versus battery, assault is in a way kind of like incomplete battery, because with battery there has to be physical damage that has to occur. It's oftentimes defined as the harmful or offensive touching, which is unpermitted because the infant on which the intervention happens does not consent, and the parental consent is very dubious. So these different premises do interact in different ways. Also, the wounding is not de minimis because, like an ear piercing, which might be argued as de minimis, the genital cutting is very invasive and permanent and leaves a lot of long-lasting effects. With breach of fiduciary duty and negligence, they tend to go hand in hand, where with negligence, there doesn't need to be a fiduciary responsibility. Like somebody who is a reckless driver might cause harm to somebody because of their negligence, but they don't have a fiduciary duty to the person that they've harmed in some cases. So here we do the standard of proving a case of breach of fiduciary duty is that there is harm and that there has been a legally inoperative consent. Medical malpractice claims tend to be a little bit more complicated and difficult. They also tend to bring up the question, is what's happening medicine? Can we really argue this in just this sphere of medicine when there are really much wider reaching implications here? So these also tend to deal a lot with the standard of care, which is sometimes tougher ground to argue. And then lastly, the constructive and intentional fraud, which really has to do with when there is misrepresentations. What are the parents told and not told? What are the omissions? What interests do doctors and hospitals have in pushing this? So there's a lot of incomplete, inaccurate disclosures. There is billing for unnecessary surgery, which gives rise to a conflict of interest. There is selling the byproducts of the surgery, harvesting tissues, which can be then sold for downstream uses. Constructive fraud is essentially intentional fraud where there might not be enough of a case to make that there is an intention. So, in a way, there can't be these imbalances where the doctor has an interest and doesn't look after the child patient's needs and happens to benefit from it at the same time and then say, oops, well, I didn't mean to. Constructive fraud is there to protect exactly from that. And then also I'd like to mention for hospitals, there's vicarious liability because they do provide the forum in which this occurs. They offer it and profit from it too. So they do share responsibility in many ways. And that is not just for vicarious liability. They do participate in the solicitation and incomplete disclosures. And then, of course, there are constitutional cases, which I won't explore too deeply because they are very complicated, but they often come down to equal protection and rights that are protected. So a very brief overview of some of the cases that have happened. The very first one was the Adam London case where the core issue is brought up, are parents empowered to consent to medically unnecessary surgery on behalf of infants? This case, unfortunately, was unsuccessful because the ruling disregarded a lot of the theory and a lot of the arguments that were brought up. There was the Fishbeck case, which took a constitutional approach and challenged an inequality in the interpretation of law. There was the Stoll case, which paved the way for young victims who want to seek retribution in a formal setting for the harm that was inflicted. There was the Flatt case, which pushed at the negligence cause of action. There was the Gievsky case, which was an older gentleman who sued on behalf of infants on the basis of battery and fraud. There was the case of the Bolt marriage, where a child's right to decide what they can and cannot be pushed on their body was protected, as children do have agency and can decide and should be able to decide what medically unnecessary interventions may and may not be performed on them. And there was, of course, the Hieronymus case, which sort of the judge ruled in opposite in a way, which in where the parental authority was acted as if they could supersede the child's medical needs. There was an anonymous case in Ottawa where someone settled out of court based off of the harm that was inflicted on them owing to a doctor and hospital's negligence. There's the current Medicaid funding, which is going on, the case that's going on about taxpayer money and misallocation. There's the American Academy of Pediatrics fraud case, and there is my case, which really interconnects a lot of these different causes of action. So a quick word about my case. I initiated it last year. I'm a self-represented plaintiff. An interesting twist is that both the hospital and doctor turned around and sued my mother for signing the form that they gave her and agreeing to the thing that they offered. So it is quite dubious what's going on there. It is probably a heavy-handed way of trying to shut it down. And it certainly did add tension, but not successful for what they were trying to do. And I hope to get my case on its way to trial in the future and to resolve a lot of these issues. So a lot of questions are brought up because there are contradictions within the claims that are made by the hospital and doctors, lawyer and insurance companies, where how can a parent expressly provide informed consent if they didn't inform themselves and it's their fault? And you might want to ask, well, now that these hospitals and doctors know better, are you informing the parents? Doesn't seem so, but we'll keep steering them towards it and punishing them for it, it seems. So one thing that was interesting to note is that the Windsor Regional Hospital website, one of the defendants in this proceeding, is very sparse. They don't include much information at all. And I am allowed to disclose what would I settle for. I can't speak to what the hospital will or won't settle for, but I can share what I will settle for. I said, if you add these things to your website, I'll end the case. No costs, right? Wouldn't that be a favorable outcome? More information for the parents, less liability for the hospital. I think it's a great solution. And are these statements controversial? I think they're pretty plain, they're pretty factual. There's not a lot of room here. I think maybe it doesn't portray the surgery or intervention in a flattering way, but it's very neutral. The lawsuit is still going on, so you can make your inferences about what is going to be easy to accomplish here. Some of the barriers. There is the statute of limitations, which varies in duration between areas. And where I'm from, it's 2 years after the day you turn 18 if there was an incident that happens when you were a minor. And this is really tricky because it also stacks things against the plaintiff, because how many people realize the harm early, have the resources, the connections, the knowledge, the means to start a lawsuit, especially at a time in their life when there are already so many things going on, right? In such a short time. But believe me, it is a difficulty here. I was 41 days past the end of my period, and they're trying to hold me to it. There's also the finding representation, which is very tough because there's a lot of reasons why firms and lawyers tend to want to distance themselves from these types of cases. They might not be perceived as profitable in the same way that other cases are. Some firms will say this isn't our area of expertise. Some firms will say, well, I'm not sure what happened to you is different from ideal care, right? So, you have a very big variation between some firms that kind of will say, okay, I see what you're saying, but best of luck. I don't think this is something we want to be involved in, right? And of course, the imbalance between plaintiffs, which are younger victims or parents who don't have the same kind of counsel and as the hospitals and doctors. And also, there's less engagement. For these kinds of cases, it will matter a lot more and have a much larger impact in the plaintiff's lives and it will be a trifle for the hospital. So for us, the risk seems to be a lot greater than for the hospital. And also, there's cases of retaliation, as we've just mentioned, where there can be pushback from different entities and individuals who are being confronted about the issue. These types of proceedings can be taxing on the health and well-being of plaintiffs, which provides another barrier. And also, it really helps when parents are on board with cases because then they can share the problems as they have come to know in the consent process with inaccurate and incomplete disclosures. There's also not a lot of precedence, which makes it tougher because there is less of a decided approach when judges decide on cases like these. And also, these cases tend to be uphill battles. It really is the way when pushing for change is, it happens and it gets tough, especially when there's a lot of things in place in the medical entities and in the law and culturally and socially that really have an interest in keeping things the way that they are. So I think that it's interesting to pursue these types of methods of redress because it's an opportunity to really have your case be heard, to present the arguments in a way that they must be considered, to really confront injustice head on, to put pressure on these different entities and weak points in the law where things can be improved, and also the benefit of finally providing everyone with equal protection from genital cutting would be immeasurably valuable. So I'd like to thank my sponsor, Attorney for the Rights of the Child, for making this trip here possible for me, and also for John Geishker and George Hill for all the help that they have and their support in the HPARB appeal case. Thank you.
The question I have is about the Canadian case that you put up way back. What happened to the Anonymous of Ottawa? What happened to that case?
So here, there isn't a lot of information about this, but what I have been able to gather, there was somebody who submitted a notice of intention to a hospital and a doctor, and the case never had to really be formally put into place because they were able to reach an agreement a lot earlier on. But unfortunately, I do wish that this was more accessible because I think that it could give an awakening for a lot of doctors and hospitals.
What were the claims in the case? Do you know? Was it a damage case or you don't know?
I don't have all the information about it.
Okay, thank you.
Anybody else? Any other question?
Is your focus entirely on the American continent, or would it be interesting for you to take some of the European cases into consideration as well?
I think that the European cases are very valuable, and I have used them as tools in some of my briefs. I cited some of the Danish and German and British guidelines that were much more forward-thinking about the issue. Yet they tended to be pushed aside as those are foreign and those are irrelevant. But I thought that a lot of the reasons why those things hold true are the same here. So I do want to continue introducing those.
Okay, excellent. Thank you.
Over here. I think we have a question here.
Were you surprised at all that the hospital and doctor came back at your mother?
Well, I think that my parents suspected it because these are the kind of approaches that a lot of insurance companies will have when they're being sued. They want to kind of sue everything that moves around them. Mm-hmm. And so my mother was a big target. Whether or not they have a strong case in it, they do want to push that because if it's a way that they can deflect responsibility. So it makes sense for them to try it, even if it's a very unstable third-party claim, as I think.
Thank you.
I don't know which one was first, but I'm going to go this way.
I was just wondering about the AAP in their last statement, 2012, I think it was, that included the cultural reasons for circumcision and then also in Ottawa. I was wondering if that kind of obliterates the need for informed consent, because my perception is that informed consent, you don't need a reason to circumcise because it's the parents choose it culturally. So I think that this is something that's happening. But the flip side of that is that it's almost an admission that there isn't the medical need for it. We're saying it's cultural, so it's almost like maybe that's the Achilles heel.
I think that's a really great point, because if they're admitting that it's not medically justified, then what place do doctors and hospitals have in really pushing and advertising something that they admit is very much to do with social norms? So we also see that in these boards and colleges of physicians, where they'll act as kind of a cultural broker. And they'll try to be like a religious shaman for, oh, and if you want a religious reason, then we'll be happy to do this for you. But then they'll at the same time say, oh no, but this is medical though. It's not battery, it's medical.
It's the shell game.
It is the shell game, like to move the goalposts. So I think it is good to attack that in multiple ways.
I wanted to congratulate you, Andrew, on bringing this lawsuit. Very impressive by yourself, and also that you really informed yourself. One concern is that people will represent themselves and not know what they're doing, and you've really informed yourself well. And then I wanted to ask if you have sought and been able to obtain any publicity.
That has been on my mind, and I look forward to being more public about my story. There are some familial complications there because the publicity has risks to it, but I think that overall, I'm not afraid of the story. I want it to be heard. I think that some of the defendants deserve the press that they can get. Look at what's going on here. Now that you know better, why can't you do better, right? That kind of idea really would be great to spread. So I think in the future that will be an important possibility.
Do you have plans to become a lawyer?
Oh, that is not the first time I've been asked that. Unfortunately, right now my journey is in a science direction, but I hope to use some of those skills and tie them in together. Mm-hmm.
Any other question?
Can you remind us who the defendant is in this case?
Both the doctor and hospital.
And the hospital is?
Windsor Regional Hospital, which is...
You mentioned that you were 44 days short on the statute of limitations. What was the statute of limitations that you were dealing with? And was it a medical malpractice statute of limitations, or was it a common, ordinary, negligent statute of limitation?
So in Ontario, it used to be 4 or 5 years. And so that would mean someone who just turns 18 gets 4 or 5 years on top of that. And these limitations periods, if someone's not familiar, is it's really a way to make things move on so that people can't be sued for something trivial that happened, like, oh, someone bumped into my car 25 years ago and now I'm getting sued for it, oh no, right? But with this, it's really interesting because you have something that a plaintiff hasn't had opportunity to seek redress yet. This issue still affects them very much and is still relevant and hasn't been addressed. So the statute of limitations almost it's this one-size-fits-all thing that's just asserted over everyone. So for me, I had 20 and a half years because there was in 2020 some pauses on limitations period because of the global situation. I ended up realizing that it expired right after it happened, and I was assiduously searching for representation at that time. Every day I just knew they're going to hold this one day against me. I know it, right? And I was doing this goose chase for representation and getting these rejections for different reasons, and I thought, I cannot wait any longer. If I want this to happen, I got to do it, and there is the potential for representation even after you've started a lawsuit, but there are disadvantages because a lawyer might not want to connect themselves with maybe a weakness in your case, because inevitably, if you don't have legal training, you're not going to do the best possible job ever, right? But there is also interesting provisions because in Ontario, there are no limitations periods for cases of assault or battery on minors. which is very applicable here, because then there's no limitations on that claim. But for medical malpractice claims, there is a 2-year deadline. So there's also something I wanted to mention called equitable tolling. When you have someone who wants to bring a lawsuit and maybe they didn't discover the entire gravity of what has happened until a later time, right? You can have maybe a dental implant that is bad and you don't know until maybe 10 years when the pain starts, right? And they can't be told, whoops, you missed your chance, too bad, because you couldn't have been expected to, right? And I think that should be really considered for young people who might not have had the chance yet and have other factors that could be impeding them, like finding representation and funding. So some judges decide very technically on, whoops, you missed the deadline, try not to be harmed next time, right? And then you have ones that will interpret things and say, you know what? I don't think the limitations laws had this particular situation in mind. What was the intent of limitations periods? And does that fit here? So it is a really important consideration to make.
We don't have any more time, unless it's a quick one. Okay.
I was just looking at my consent to treat for my doctor, and there's an arbitration clause in there. It says that I have to go through arbitration. How is that affecting the opportunities to seek legal redress?
So the laws for arbitration are really different for, I think, different states, and really varies depending on the agreement that's signed. But I do think it can be another obstacle for people who want to seek redress, because it can be a way of precluding them from getting to the stage where they can really present the issues at hand. But I think that it'd be important to look into that more. Mm-hmm.
I think I speak for the lawyers in the room to say that was incredibly impressive. I think he needs to go to law school tomorrow. I think you could teach the torts course. Really fabulous. I don't think I've ever seen a layman with such knowledge and such detailed knowledge of the intricacies of the tort system. It's really impressive. Thank you, Andrew.